Hello, my name is Marco Brigaglia from the University of Palermo, Italy. I'm going to give a lecture on cognitive biases in adjudication. The lecture is part of an e-learning course on legal reasoning and cognitive science targeted at law students and legal professionals. The course is realized in the frame of the EU project Recognize. If you're interested in knowing more about this project, I refer you to the project's webpage at recognize.academy. The lecture is divided in two parts of approximately 20 minutes each. The topic we are going to discuss are so-called cognitive or psychological biases in the context of adjudication. The expression cognitive biases requires a brief introduction. The basic idea is this. Our thought and decision making often take courses which significantly deviate with respect to acknowledged standards of rationality and which are thereby likely to lead us to mistaken conclusions or decisions. Some of these deviations are not random but follow regular patterns associated to predictable, systematic mistakes. The term cognitive biases or simply biases is used sometimes to refer to these patterned deviations from or distortions of standards of rational thought and decision making. More often, the term is used to refer to the systematic mistakes associated to such deviations or distortions. In this broad category are also included patterns of thought and decision making whose simply labeling as deviations from rationality is perhaps unfair. These are so-called heuristics, cognitive shortcuts which simplify our judgment and decisional tasks. The peculiarity of heuristics is that although they deviate with respect to acknowledged standards of rational thought and decision making, they are nevertheless useful because under non-ideal conditions such as limited information or time constraints, they make it possible for us to reach, on a significant percentage of occasions, a good enough, although not optimal, conclusion or decision. This advantage comes, however, with a cost, and the cost is a significant likelihood of incurring into biases, systematic mistakes. We will come back later in more depth to the notion of heuristics and biases. For the moment, bear in mind these simple definitions. Biases are systematic mistakes associated to patterned deviations from standards of rational thought and decision making. Heuristics are a subset of these patterned deviations, cognitive shortcuts that are often useful, but that may easily lead to biases. Many kinds of cognitive biases are already well known to most of you, even if probably not many of you are used to the term biases. Think, for instance, of racial or sexist prejudice. Think of the tendency to jump to conclusions before considering relevant reasons, or to the tendency to believe things that please us. Contemporary psychological inquiries, however, go much farther than common sense. First of all, psychological inquiries enable us to answer questions about the frequency by which biases plague our thought and decision making, or the thought and decision making of particular categories of decision makers in particular contexts, such as in our case, judges in adjudication. As it turns out, the insurgency of biases is significantly more frequent than common sense will admit. And unexpectedly, this is also true in the case of expert decision makers such as professional judges. Second, psychological inquiries lead to the discovery and the understanding of kinds of biases unknown to common sense, or if not literally unknown, not well understood by it. Third, psychological inquiries lead researchers to the uncovering of both the factors which contribute to bringing about relevant biases and the factors which contribute to preventing their insurgency. Contemporary psychology features an enormous number of empirical studies and many different research paradigms dealing with cognitive biases. In particular, the number is high of inquiries concerning cognitive biases in adjudication. Moreover, in the last few years, such inquiries have increasingly become the object of interest from the perspective of non-specialists and in particular of scholars in jurisprudence and legal theory. It is not difficult to understand what motivates this interest. Cognitive biases may significantly and deeply affect the quality of judicial decisions. The problem is thus to ascertain their impact and above all to understand how to prevent or contrast them. Knowledge of the cognitive biases judges and legal professionals generally are liable to, and knowledge of the factors contributing to their insurgency hopefully helps us in devising strategies for preventing or contrasting them. These strategies may concern legal education, the division of, and organization of labor in courts and other legal institutions, or even the design of legal procedures. In this lecture, I will limit myself to dealing with the problem of cognitive biases in adjudication. I will not discuss proposals for coping with them. However, it is important to keep in mind that the problem posed by cognitive biases is also practical, not merely a theoretical one. It is first and foremost a matter of legal policy that requires searching for appropriate solutions. I will not attempt to provide a wide-ranging review of the main inquiries on cognitive biases in adjudication. Rather, I will focus on a very limited sample of studies in this field, studies whose findings are unexpected and disturbing. In the first part of the talk, I will introduce a renowned and discussed study conducted by a team of psychologists in Israel a decade ago. This study concerns the correlation between judges' decisions and their meal breaks, how judges' decisions change according to the amount of time elapsed since their latest meal break. Discussing this study will enable me to introduce one of the most important factors leading to cognitive biases: reduced capacity to exert control on our decision making due to sustained and prolonged effort. The second part of the lecture will deal with the research program usually named Heuristics and Biases. After a sketchy outline of this program, I will focus on one heuristic named anchoring. I will present the findings of a few studies concerning the role played by this heuristic in adjudication. In the background of this study on the hungry judges is the echo of the views of American legal realists. I do not know how familiar you are with this family of conceptions of the law and of legal reasoning. The only thing you need to know is that some of the American legal realists, notably Jerome Frank, emphasized the influence that the most varied psychological factors have on judicial reasoning and decision making, including patently irrelevant factors, inconsistent with the standards judges themselves appeal to in justifying legal decisions. Critics of American legal realism caricaturize such claims in the maxim, "justice is what the judge ate for breakfast." By the way, it is disputed whether Frank or other legal realists ever meant something close to this maxim. If you want to know more about this, I refer you to a recent article by Dan Priel. In any case, the authors of the study I'm going to present took seriously this seemingly absurd maxim, treating it as an empirical hypothesis to be experimentally tested under control conditions. This study examined over 1,000 rulings rendered by 8 judges who presided over 2 different parole boards. Judges' working days were partitioned in 3 sessions, separated by 2 meal breaks, a late morning snack, and lunch. What the researchers found was that the percentage of favorable rulings reached its peak at the beginning of each session and then gradually dropped to nearly zero until the next meal break, after which it would rise again. Bluntly put, the hungrier the judges were, the stricter their decisions. According to this study, the amount of time elapsed since the beginning of the session was not the only factor statistically correlated to the ruling. Nevertheless, it seems to have influenced it significantly. Ceteris paribus, the probability of a favorable ruling was much higher when the case was decided upon at the beginning of the session rather than at the end. In sum, a legally irrelevant factor, the moment at which the case was decided upon, seemingly affects the decision to a statistically significant degree. In the end, the caricature of American legal realism devised by its detractors seems to be not off the mark. Judges' decisions are influenced, it seems, not quite by what they ate for breakfast, but by the amount of time elapsed since their latest meal break. The researchers did not simply detect and record a correlation between the ordinal position of the ruling and its content, acceptance or denial of parole. They also advanced a hypothesis about the causal mechanism responsible for this effect. Roughly, the hypothesis is this: decision making under uncertainty is a cognitively demanding activity requiring mental effort. Decisions which aspire to change the status quo, in this case acceptance of parole, require more mental effort than decisions which confirm the status quo, denial of parole. There are, according to the authors, two cues of this. On average, acceptance took first more time than denial, and second, it was supported by longer arguments. In other words, in the case of acceptance, a change of the status quo, judges feel a heavier burden of argumentation than in case of denial. As a consequence, the mental effort required for the former kind of decisions is greater. Human beings have limited cognitive resources that are depleted by cognitively demanding tasks, such as decision making under uncertainty, in particular when decisions aspire to change the status quo. Thus, during working sessions, judges' cognitive resources get progressively depleted, leading them to adopt the less demanding decision, denial of parole. During breaks, rest and food restore judges' cognitive resources, thus enabling them to make more demanding decisions again. According to the researchers, then, the distributions of decisions depended on two interacting factors. The first factor is the progressive depletion during working sessions of cognitive resources required for decision making under uncertainty and their recovery thanks to the meal break. This factor is called ego depletion. The ego depletion construct instantiates a so-called resource model of control. Control is roughly the capacity to act according to the demands of a given task in the face of conflicting tendencies. Resource models of control hypothesize that our control capacities depend on the availability of a physiological resource that can be depleted and reintegrated, for instance, glucose. The second factor, hypothesized by the researchers, is the tendency to confirm and support the status quo, a tendency which can be overcome only by virtue of additional cognitive effort. This tendency is precisely a heuristic, a simplified way of solving a cognitive problem, a cognitive shortcut that on the one hand allows us to reach on a significant percentage of occasions a good enough solution, but on the other hand leads us to systematic mistakes. Let me add a few comments on this study. First, this study brings into the foreground the importance of psychological inquiries for issues concerning the organization of judicial labor. If the findings of the study and its hypothesis were right, the quality of judges' decision-making could be improved through a better organization of the working sessions, for instance, more frequent breaks. This leads us to a trivial, but I think very important point that has to do also with legal education. The quality of judicial labor as of any kind of labor, is deeply affected by organizational issues, time schedules, breaks, number of cases to be treated, divisions of labor, and the like. In spite of its importance, however, the organization of legal labor is a largely neglected topic in standard legal education. Second comment. Judges were aware neither of the dependency of their decisions on the amount of time elapsed since the beginning of the session, nor of the causal factors that, according to the researcher's hypothesis, were responsible for this. There is ego depletion and the status quo heuristic. Judges consistently believed that their decisions were effectively guided only by legally relevant reasons. Their assessment of these reasons was, however, biased, according to the researchers, by unconscious factors that neither we nor the judges themselves would regard as justifying reasons. That is, the decisions were affected by factors that may explain them, but that cannot justify them, that cannot make them correct. This is one of the most disturbing findings of contemporary psychology, the possibility and the frequency of profound mismatches between the reasons we tend sincerely to adduce in order to justify our decisions and the real psychological factors that causally affected our decisions. You can get an idea of this through one of the experiments reported in a seminal article by Nisbet and Wilson. The experiment was conducted in a commercial establishment under the guise of a consumer survey. Subjects were presented 4 identical pairs of nylon stockings, and they were asked to assess which pair was of the best quality, to choose one, and to explain why they had chosen it. There was a strong position effect. The rightmost stocking was by far the most chosen one. Subjects were totally unaware of the position effect. Of course, they never mentioned it to justify their choices. They instead referred to differences in quality that did not exist. In fact, the stockings were identical. They also vehemently denied that their choices could have been by any means affected by something so irrelevant as the position of the stockings. But indeed, the position did affect their choices. Third comment, one could also wonder how conclusive this study is. In general, its findings are widely deemed as quite robust. It is widely believed that the amount of time elapsed since the beginning of the working sessions significantly affected the content of the relevant rulings, and that such effect can be generalized. And it is also widely accepted that the interaction of heuristics and ego depletion or analogous mechanisms are likely to affect deeply judicial decisions. There are, however, some critical voices. Some have attempted to challenge the core finding of the study, that is, the causal dependence of the decision on the amount of time elapsed since the latest meal break. Others have questioned the magnitude of the effect, and others still have put into doubt the explanation of the effect. One study in particular has questioned the role of the status quo. But more importantly, resource models of control and the ego depletion construct that were very popular at the time of this study have recently become the object of strong criticisms. One of the criticisms runs approximately as follows. If control depended on a limited resource, a stronger motivation to exert control couldn't affect performance. If you are out of gas, the fact that you really want to go to a certain place cannot make your car move. However, this is precisely what happens. Failures of control are indeed reduced if the motivation to exert control is increased. Okay, we will come back in a while for the second part. Thank you very much for your attention. Bye.